As we conclude our study of the Arizona Statute of Frauds, it is essential to connect what we have learned about written agreements to one of the most important professional relationships in real estate: the employment agreement between a licensee and their client. Whether representing a buyer, seller, landlord, or tenant, a real estate licensee's authority to act on behalf of a client must be based on a valid, written agreement that satisfies the requirements of the Statute of Frauds under Arizona Revised Statutes, Section 44101. This provision specifically states that an agreement authorizing or employing an agent or broker to purchase or sell real property for compensation must be in writing and signed by the party to be charged. Without a written agreement, the relationship is not legally enforceable, and the broker cannot claim or receive a commission. The Statute of Frauds serves as a safeguard not only for clients, but also for licensees, ensuring that every party's rights and obligations are clearly defined and documented. The requirement for written employment agreements eliminates misunderstandings about compensation, duties, and representation. It also upholds transparency by providing a verifiable record of consent and authorization. For example, if a real estate agent verbally agrees to sell a client's home, but no written listing agreement exists, the agent would have no legal right to collect a commission, even if the property is sold as a result of their efforts. This rule was upheld in Butterfield v. McKenzie, 1966, where the Arizona Supreme Court ruled that brokers cannot recover commissions for the sale of real property without a written, signed listing agreement, regardless of the work performed or oral promises made. Employment agreements in real estate are most commonly established through two forms: the listing agreement and the buyer-broker agreement. A listing agreement is a written contract between a property owner, the seller, and a licensed broker, authorizing the broker to list, market, and sell the property for a specific commission. It defines the scope of authority granted to the broker, the listing price, the duration of the agreement, and the commission structure. The Arizona Association of Realtors listing agreement template, widely used in practice, meets the requirements of ARS Section 44101 by providing written evidence of both parties' consent and including their signatures. The buyer-broker agreement functions similarly, but applies to buyer representation. It is a written agreement between a prospective buyer and a licensed broker, in which the broker agrees to locate and negotiate the purchase of property on the buyer's behalf, typically in exchange for a commission or fee. This agreement is equally protected by the Statute of Frauds and ensures that the broker is legally entitled to compensation once a property is purchased. The importance of these agreements was reinforced through ARS Section 32-215.1.02, which requires that real estate employment agreements be in writing, signed by all parties, and include a definite expiration date and a clear description of the services to be performed. The written employment agreement also establishes the agency relationship, which defines the legal duties owed by the broker to the client. Under Commissioner's Rule R4-28-1101, licensees are required to act with honesty, reasonable care, and loyalty to their clients. These duties can only be properly established and enforced through a written agreement that identifies the client's role, whether as a buyer, seller, landlord, or tenant, and the broker's scope of representation. Without a written contract, the broker-client relationship lacks clarity and enforceability, which may result in ethical and legal violations under ARS Section 32-2153 for dishonest or negligent conduct. In Arizona, employment agreements are not only a matter of contract law, but also an essential element of regulatory compliance. ARS Section 32-2151.01 requires designated brokers to maintain all written agreements related to real estate transactions for at least 5 years. This includes listing agreements, buyer-broker agreements, and property management contracts. These records serve as proof of compliance with the statute of frauds and are critical during ADRE audits or disputes regarding commission entitlement. Electronic signatures and digital platforms have further strengthened compliance with the statute of frauds. The Arizona Electronic Transactions Act, ARS Section 447001 ATCQ, authorizes the use of electronic signatures and digital documents for real estate contracts, including employment agreements. This modernization allows brokers and clients to execute binding agreements efficiently while maintaining legal validity. For example, a buyer and broker may sign a buyer-broker agreement via DocuSign, and that agreement is equally enforceable as a paper contract. Understanding the statute of frauds application to employment agreements protects both licensees and consumers. For brokers, it ensures a legal right to compensation and shields against disputes about agency authority. For clients, it confirms the scope of representation and provides a written record of agreed terms. This mutual protection fulfills the intent of the statute of frauds to promote clarity, prevent fraud, and ensure that all parties engage in real estate transactions with full understanding and transparency. Review Summary. Under ARS Section 44101, all employment agreements between real estate licensees and clients must be in writing and signed by the party to be charged to be enforceable. This includes listing agreements, buyer-broker agreements, and property management contracts. The written agreement must specify the scope of representation, commission terms, and an expiration date under ARS Section 32215.1.02. Without a written contract, brokers cannot legally collect commissions or enforce agency relationships. The requirement supports the broader purpose of the statute of frauds, preventing fraud, ensuring mutual consent, and promoting professionalism in real estate practice. Discussion. Why must employment agreements between licensees and clients be in writing? Answer. To comply with ARS Section 44101 and ensure the agreement is legally enforceable, transparent, and protective of both the client and the broker. What happens if a broker sells a property without a written listing agreement? Answer. The broker cannot legally claim or collect a commission, regardless of their role in the transaction, as held in Butterfield v. McKenzie, 1966. What statutory provisions outline the requirements for real estate employment agreements in Arizona? Answer. ARS Section 44-101 and ARS Section 32-2151.02, which require that all such agreements be written, signed, include a definite expiration date, and clearly describe the scope of service. Closing remarks. The statute of frauds establishes a firm foundation for the professional and ethical practice of real estate by requiring that employment agreements between licensees and clients be in writing. These agreements not only protect the right of brokers to compensation, but also safeguard the interests of clients through documented consent and clear terms of representation. In modern Arizona real estate practice, written contracts, whether signed on paper or electronically, serve as both a legal necessity and a mark of professionalism. By adhering to these standards, licensees uphold the integrity of their profession and strengthen the trust that is fundamental to every client relationship.